And here we go. All right, guys, it's Tuesday, a little bit after 3:30. We're about 2 minutes late. Today being St. Patrick's Day, I thought that a good topic to cover today would be questions regarding DWI, as people like to go to various bars and whatnot on St. Patrick's Day. So Thomas is here with me today. And I had told y'all earlier that Thomas and I have written a DWI book, and it's finally been published, and we have copies now, and you can download a free copy through the website on the DWI page section of the website. But anyway, we have some questions here that have been sent to us, and Thomas will take some and I'll take some. The first question is, what is the difference between a DWI and a DUI? So Thomas, I'm going to let you take that one.
Sure. The primary difference between the two is the age of the individual who's been accused. So DUI applies to an individual under the age of 21. And if they are operating a motor vehicle and they have any detectable amount of alcohol, then they could be charged and found guilty of DUI. Now, it's important to remember, though, that an individual who is still under the age of 21 alcohol content of 0.08 or higher. Do what?
You froze for a minute, at least on my end you did.
Let's see, where did I cut off?
I think you were talking about the DUI distinction.
Okay, so going back to what I was saying, it's primarily the age of the individual accused. If you're under the age of 21 and you have any detectable amount of alcohol, you can be charged and convicted of DUI, or driving under the influence. DWI is typically anybody that has a blood alcohol content of 0.08 or higher. And so it's important that the distinction is basically, if you're under the age of 21, any detectable amount of alcohol, you can be charged with that offense. However, anybody who has a 0.08 or higher could be charged with DWI.
Okay, and I don't know if you can see the comments, Thomas, but Ashley and Jeff Stewart have called us out for not wearing green. So, okay, the next question is, and Thomas, I'm going to let you take this because it's related, and it is, what is the minimum blood alcohol level in Texas?
So, as I was kind of mentioning before, and since we made that distinction between DWI and DUI, under 21, it's any detectable amount. So if there's anything in there. But for DWI, it's 0.08 or higher. So the minimum would be 0.08.
All right. The next question is, does a DWI affect employment? And, you know, the answer is maybe, because it's going to depend on what your employment is, and then whether or not your employer has any particular rules regarding DWI. We really only see that in cases where your employment requires driving, specifically driving as part of your employment. So if you're a delivery driver, then they may have rules within your company that say if you're charged with DWI, you cannot operate for some period of time. Sometimes we run into problems where someone is a driver, their company doesn't have a policy, but if it's above, let's say, a 0.15, and you're required to have an ignition interlock on any vehicle you drive, then your employer won't let you put an ignition interlock on a company vehicle, and obviously that could affect your employment. So if you're employed in something other than a driving type of job, it's probably not going to have an effect, again, unless your employer has some type of specific policies regarding being arrested for offenses and continuing employment. We're going to go off topic 1 second. Yes, Susan, we're doing this right now. And then J.C. Faye Wilkes, I'm going to come back to your question as soon as we finish the DWI question. Okay. Can a DWI make it hard to get an apartment? I'll take this because it was related to employment like the last one. I've never seen it affect the ability to reside in a particular apartment complex. I have seen 2 types of offenses affect the ability of someone to live in an apartment complex, and that are crimes of violence and drug crimes. I've not really heard of many more. There are some apartments that do have a prohibition of convictions for crimes of moral turpitude, like theft, those types of things, but I've never heard of an apartment complex denying someone because of a prior DWI. All right, the next question is, can a DWI be a felony? And I'll just keep with this one. The answer is yes, in more than one way. If it's your 3rd or more, then it's a felony. So if you've had 2 previous DWIs, every DWI you get after that could be a felony or will be charged as a felony. It could also be that it's your first DWI, but you have a child passenger under the age of 15 that will also make you a felony DWI. Let's see. Thomas, I'm going to let you take this one. What is the punishment for a first-time DWI?
All right, so there's going to be a little bit of an overlap on what you were kind of just talking about, but in general, a first-time DWI is a Class B misdemeanor. It's punishable up to confinement in the county jail up to 80 days or 180 days, and a fine not to exceed $3,000. There's some additional fines that can be imposed as a result of the new legislative changes in 2019. Many of these things can be negotiated, but that's kind of the baseline for first-time DWI. There are things that can increase the punishment range for a first-time DWI. So, like Mark was saying, first time, but you've got a child under the age of 14, and that would make it a state jail felony, which is punishable by not less than 180 days, but no more than 2 years, and a fine not to exceed $10,000. And I'm sorry, the confinement would no longer be in the county jail, but it would be in the state jail division of the Texas Department of Criminal Justice. So with that one, we've already kind of discussed. There is something else that can affect the punishment range for a first-time DWI, and that would be if you have a blood alcohol content of 0.15 or more. In essence, what that does is that raises the punishment range from a Class B misdemeanor to a Class A misdemeanor, which is punishable by a term of confinement in the county jail not to exceed 365 days, and a fine not to exceed $4,000, and then the additional statutory fines that were in place from the 2019 changes to the laws.
Okay. Thomas, you're going to keep going. The next question is, what is the punishment for repeat offenses?
So we touched on this a little bit, but if it's 3rd or more, or if you have at least 2 prior convictions for DWI or any intoxicated offense, you can be charged with the 3rd or more, which would make it a 3rd degree felony. That is punishable by not less than 2 years, but no more than 10 years in the institutional division of Texas Department of Criminal Justice, and a fine not to exceed $10,000. Um, that's the felony range. And as you can kind of logically follow, they stack based on how many prior convictions you've got. So first time baseline is a Class A misdemeanor. The next time, if you were charged with this, it would be elevated to a Class B misdemeanor, DWI second, which is a Class A. So actually, I may have fumbled that up a little bit. Baseline is a Class B. If you get charged with a second one subsequent to that conviction, it's elevated to a Class A. Then you get charged with the subsequent one after that. After both of those convictions are final, then it's a third-degree felony.
And what is the punishment if you are underage?
So it's actually very similar. It's under a different code section. It's not under the penal code section, but it's a term of confinement not to exceed 180 days, a fine no less than $500, but not to exceed $2,000. And then they do apply some community service requirements, where a portion of those community service requirements have to be related to the deterrence and explanations of alcohol abuse.
All right. I'll take this one. How long does a DWI stay on your record? And that's not necessarily an easy question to answer. A shortcut answer is that a conviction stays on your record for life. So it has happened. I think we have a case right now where one of the prior DWIs making this one a felony was like from 1989. But the answer is a little bit more complicated in today's world. Most counties, like here in Galveston County, have a pretrial diversion set up where if you're a first-time offender with a DWI, if you take this special program and you complete it, then you actually are not convicted, and it can later be removed from your record. Similarly, with the new deferred offerings for the counties that didn't have a pretrial diversion, it's a similar situation. So, but if it's a flat conviction, so for instance, if you go to trial, the jury finds you guilty, the jury gives you some punishment, that will be on your record for the rest of your life under the current code. Wouldn't you agree, Thomas?
Yes, sir.
Okay. I'm going to let you take the next one. And this question is a precursor sort of to FSTs, but, and we'll get to that in a minute, but can you be convicted of DWI without a breathalyzer is the question that was asked.
Technically speaking, yes, because what you'll find under the definition of, Chapter 49, the intoxication offenses, intoxication is defined in two different ways. It's with blood alcohol content of 0.08 or higher, or it's the loss of normal use of your mental or physical faculties. So what that's kind of keying or hinting towards everybody is that you don't need that number in order to prove intoxication. So, for example, if you refused a breathalyzer, you refused a blood test, they didn't get a warrant to seize any of those things, but somebody's fallen down drunk, obviously intoxicated, admit to the officer that they've had 12, 15 beers, that's going to be a case where the state does have enough evidence to where a jury might be convinced to convict an individual for DWI. Having said that, though, it does make it more difficult. Performance on field sobriety tests can be very subjective. Not only that, there's very technical ways in which the officer has to instruct and basically tell the individual how to perform these. And if they deviate from those instructions and the way this whole thing has been standardized, enough of those can get to a point to where the field sobriety tests are no longer admissible. But something that's been happening currently in Galveston County, it wasn't always this way, but the trend is starting to increase. If you refuse a breathalyzer, the officers are, I've kind of noticed an uptick in this where they are now getting blood warrants. They're taking you to a hospital, they're drawing your blood. And so with that, you know, it's kind of a technical way based on the way the question was worded, but if you refuse a breathalyzer, they can still always apply for a warrant and try and get your blood.
So the next question is, what happens if you refuse a breathalyzer? So just, I guess, sort of tie that in, although
sure,
and the legal consequence is not that they'll get a blood warrant, but there are consequences if you refuse. I guess we should just tie that into both, either breath or blood.
Okay, so you know, as I was saying, they have the potential to get a warrant. But those things aside, if you refuse, the main important consequence is a license suspension. It's if you basically refuse breath or blood, and even if they do get a warrant, it doesn't matter, you've refused at that point, they can suspend your license. Now, there's a very critical time period should that be the case. You have 15 days to contest any suspension on your license. If you don't make that contest timely, then you've considered to have waived it and it's done, it's over, your license is suspended. Getting an attorney who knows the procedures, knows how to go through these hearings, they're called ALR hearings, they can guide you and get you to a point to where potentially your license doesn't get suspended, but if nothing else, it gives the defense an opportunity to get evidence early and also to get an officer on the record testifying about the DWI, which can later be used to possibly impeach them should you ever get to trial.
Before I get to the next question, and no one asked about field sobriety tests, but I'm sure most of our audience knows that the field sobriety tests are what officers do, sometimes on the side of the road, sometimes at the station, sometimes both. And it's a series of physical agility, so to speak, tests that the officers give you to try and determine whether or not they think you're intoxicated. Thomas has been trained and certified in administering the field sobriety tests. And when I say he's been trained and certified, I don't mean that, you know, he went to some defense version of training. I mean, he went to the actual officer training. I believe that when he was in the class, he was the only person in the class that was not a law enforcement officer. So he has the exact training and certification that many of our local law enforcement officers do. And, you know, that's just important because Thomas, when he's cross-examining an officer or just looking at, you know, someone's dash cam or body cam footage, he knows exactly what to look for because he went through the same training as that officer administering the test. And so we have here a question: what should I do if I'm pulled over by the police for suspicion of DWI? And, you know, I'll start, and Thomas, you can just kind of add in.
Sure.
You know, the easiest thing to do is treat it like any other traffic stop, like if you were speeding. You know, just be respectful and answer the questions that you want to answer and refuse to answer or refuse to do the tests, but don't do anything nasty. You know, we have seen people get convicted of what we call being a jerk. If you're obnoxious and belligerent to the officer, the jury watching that footage later just doesn't like you. And it's easy for the state to stand up and say, who would act like that other than an intoxicated person? So, you know, if you're going to ask me, I'm going to say refuse all field sobriety tests and refuse either blood or breath. but do it respectfully. You do not have to be a jerk to the officer. If it's gotten to that point, you're going to go to jail anyway, so you might as well just accept it. Now, for some reason, a lot of people don't, I guess it's because we're brought up, you know, to be compliant with officers, right? You have the right to refuse blood or breath. Refuse it. Make them get a warrant. If you have refused and they have to get a warrant, that gives us more to fight, more to pick apart. They have to articulate to a judge sufficient cause to get that warrant. Maybe I can attack what that officer writes in the warrant. So refusal is important. If you volunteer, it's in writing. It's hard for me to undo that you signed it and consented to the testing. So be respectful to the officer, but refuse to participate in the investigation is what I tell most people. What do you think, Thomas?
I would agree with all of that. I mean, why help them do their job? But again, keeping it respectful, you know, treat it as, you know, you're in a professional environment. And to kind of add to the quote unquote convicted of being a jerk, let's say when I was a prosecutor, not only did I handle certain cases, but I saw others that were denied the ability to take part in the pretrial diversion programs because of their attitude and the way that they were to an officer. So it wasn't because they didn't qualify for any other reasons, but when the chief prosecutor reviewed the application for the pretrial program, she didn't like the way that he was disrespecting the officer and denied it. And this is, when we're talking about pretrial programs, these are at the discretion of the DA's office. They don't have to offer them. There's nothing that guarantees or that entitles anybody to it. So understand that there's the potential that a prosecutor is going to be watching this video, and it's not only going to affect potentially your ability to enter into the pretrial program, but also understand that it's going to affect the way that they treat that case in terms of whether or not they make, you know, what type of plea agreement they offer you. Sometimes you might get, you know, a 12-month probation offer, but if you are a jerk to the officer, then, you know, that offer can go up or the fine can go up, and they find different ways to penalize you based on your demeanor and your behavior on the side of the road.
All right, the last question is, can a lawyer get DWI charges dismissed? And so, quite simply, the answer is yes. You can get anything dismissed. DWIs, believe it or not, are a very complex and thorough investigation, you know, that begins with an analysis of the stop. What was the reason that you were stopped? Then, let's say the reason was speeding. Once the officer has established that he pulled you over because you were speeding, what can he articulate that was cause to further detain you for a DWI investigation? That's our next step. Then, you know, we'll go through the SFTs, whether or not there was blood or breath, whether or not the officer is trained and certified in SFTs. When was the last time, if he was, when was the last time that he recertified his training and certification? If you did give blood or breath, was the machine properly calibrated on the breath side? When was the last time it was calibrated? When was it serviced? There's just so much. On the blood side, how was the blood stored? Was the blood stored properly? Was it transported properly? Is the chain of custody proper? There's so many things that go into a DWI investigation that, yes, we are oftentimes able to find something that just says, aha, and so we can get the case dismissed. So that's about the best answer I can give on that, unless you got something to add, Thomas.
No, well, I mean, for example, we had a case where the police agency put the blood that they drew, they put it in the mail, and they sent it off to the police lab. So, yeah, you know, what the effect of that is, it messes with the chain of custody, and nobody can really testify to how it was stored during that period, how it was handled. And what that does is it creates an issue with the validity of the results. And a lot of those things, sometimes they're not immediately apparent when you're watching the video, because you get documentation of where the blood and how it was sent. So yeah, it's multi-layered, very complex, and there's lots of little stones to uncover things that'll ultimately go your way.
And don't forget the officer who drove around with the blood in the trunk of his car for 3 days. Anyway. Okay, so that's all we had on the DWI. JC Faye Wilkes here on the chat says, can I get my gun rights back after I am off parole? And if so, how? So believe it or not, this is an extremely complicated question. And the answer I'm going to give you is no, but I'll give you a little bit of an explanation why. Under the Texas Penal Code, there is a statute, well, it's in the possession statute of a weapon, but it is a defense if after a certain period of years, the gun is in your home and the gun is for home protection. And that's from the time you would have gotten released from prison or off of parole. The problem is the federal government does not recognize that statute. So while Texas may not prosecute you, the feds can. I once spoke to an agent who said they have had a problem in Texas with people being off of parole paper conviction for years and years, and going to academy to buy a rifle, let's say, for hunting or whatever, and they do get cleared because academy, I think, goes back 10 years. And they find that someone had a conviction for a felony more than 10 years ago. And the agent told me that in many of those cases, what they do is go to the person's house, knock on the door and say, hey, you're not allowed to have that gun. We'll give you a chance to surrender. If not, we'll file on you. So if you ask two different attorneys, you're going to get two different answers because of the Texas statute. The problem is the federal government does not recognize that exception. And so while you may be able to have a gun at home under Texas law, you cannot under federal law. So JC Faye Wilkes, hopefully that answers your question. If it's not specific enough or you have a different set of facts you want to run by me, you can call the office and we can discuss it. So that's it. We made it almost a solid 30 minutes. We'll see y'all next Tuesday.